Okay, we are live and recording.
Very good. I'd like to call the meeting to order. Aloha mai kako. Good morning, everyone. This is the November 15th, 2023 Land Use Commission meeting. This is a hybrid meeting, which is being held using interactive conference technology, linking video conference participants and other interested individuals of the public via the Zoom internet conferencing program. For all meeting participants, I would like to stress the importance of speaking slowly, clearly, and directly into your microphone. Before speaking, please state your name and identify yourself for the record. All meeting participants are being recorded on the digital record of this Zoom meeting for court reporting purposes. Your continued participation is your implied consent to be part of the public record of this event. If you do not wish to be part of the public record, you should exit the meeting now. Court reporting transcripts are being done from the Zoom recording. Also, please note that due to matters entirely outside of our control, occasional disruptions to connectivity may occur for one or more members of the meeting at any given time. If such disruptions occur, please let us know and be patient as we try to resolve the audio visual signals to effectively conduct business. Please note that the Q&A feature of Zoom will only be monitored for signing up for public testimony. All other communications will not be addressed or part of the meeting record. Communications can be emailed to our email at dbed.luc.web@hawaii.gov. I will also share with all participants that we will take breaks from time to time, nominally 5 to 10 minutes every hour of the meeting. My name is Dan Giovanni, and I have the pleasure to serve as LUC Chair. We currently have 9 seated commissioners. Participating with me today are Commissioners Leo Ohigashi from Maui, Commissioner Michael Yamane from Kauai, Commissioner Gary Okuda, Commissioner Kamakea Ohelo, Commissioner Ata, and Commissioner Lee, all attending in Oahu. And Commissioner Carr Smith is attending from Hawaii Island. Commissioner Kahele is excused from today's meeting. Also participating are the LUC Executive Director, Daniel Orendanker, LUC Chief Planner, Scott Derrickson, LUC Staff Planner, Martina Segura, LUC Chief Clerk, Ariana Kwan, and LUC Attorney General, attending by Zoom, Dan Morris. Our first order of business is the adoption of the minutes from our meeting of October 18-19, 2023. Ms. Kwan, has there been any written testimony submitted on the October 18-19, 2023 minutes?
No, Mr. Chair.
Thank you, Ms. Kwan. Are there any members of the public who have signed up to testify on adoption of the minutes?
Leo Higashi has his hand raised.
Commissioner Ohigashi.
I was just going to make the motion when it's necessary.
Okay, hold on a sec. Commissioners, are there any corrections or comments on the minutes? If not, is there a motion?
Mr. Chair, could I interrupt, please? We're having a tremendous amount of feedback here. Can we hold off for a couple of minutes until we resolve the problem?
Of course. So we'll take a short recess while you try to resolve that. That's electronic feedback? Or is it Mr. Ohigashi feedback?
No, it's within the conference room.
Okay, thank you.
Hello? How's the feedback? Are we?
You're good. We hear you well.
Okay, I think it's a little bit better in the room now, less squeaking, but there's still a little bit of squeaking, but we will try to continue and hopefully it won't squeak too much on our end.
So you'd like me to restart?
Yes, please, with the testimony for the minutes.
Okay, so I'm going to go back up a little bit because I think I called on Ms. Kwan to affirm if there anyone had signed up for public testimony, and I'm not sure I got a clear message, so I'm going to repeat that. So Ms. Kwan, have any members of the public signed up to testify on the October 18, 19, 2023 minutes?
No one signed up to testify on the minutes.
Thank you. Commissioners, are there any corrections or comments on the minutes? Hearing none. Hearing none.
Yeah, this is Gary Okuda. I'd like to abstain because I don't believe I was at either of the meetings. Thank you.
Very well. Thank you, Commissioner Okuda. Do we have a motion to adopt the minutes?
So move.
Thank you, Commissioner Ohigashi. Do I have a second? Thank you, Commissioner Carr-Smith. It is noted for the record that I'm going to take a voice vote, but Commissioner Okuda is going to be silent. So all in favor of adoption of the minutes signify by saying aye.
Aye.
Any opposed? Hearing none, the minutes are adopted. Thank you very much. The next agenda item is our tentative meeting schedule, and I'd like to call on Mr. Orendanker to present the schedule.
Thank you, Mr. Chair. Tomorrow we will be in Kona for A81-525 WIO Limited Partnership Motion for Reconsideration. We do not, on December 6th.
Excuse me. We can't hear you very well.
On December 6th, we will be on.
Mr. Orendanker, would you back up to the beginning with the November 16th?
Okay. Tomorrow we will be on in Kona for the WIO Limited Partnership Motion for Reconsideration. On December 6th, we will be on Oahu for a presentation on the OPSD soil study. On January 24th, we will be on Oahu for the Halekua Development Status Report. And on February 7th, we will be in Kona for the Gamrex Inc. Status Report. On February 21st, we will be on Maui for the AMFAC HHFDC Status Report. We have tentatively penciled in Waimanalo Gulch for March 20th. Thank you very much, commissioners. We would appreciate you not or keeping the dates for the various other meetings available, as we have petitions and special use permits that may come online. Thank you.
Thank you, Mr. Orendanker. Commissioners, do you have any questions or comments on the tentative agenda? Hearing none. Thank you. Our next agenda item is a discussion of the proposed rule amendments to the LUC Administrative Rules, Chapters 15-15. The proposed rule amendments can be viewed online at luc.hawaii.gov/2023-administrative-rules. On November 3rd, 2023, the Land Use Commission staff individually sent the commissioners the draft rule amendments for review and comment. LUC staff edited the proposed rule amendments to reflect commissioners' suggested edits. On November 7th, 2023, the LUC staff posted the draft rules for public review and comment. I'd like to, at this point in time, for purposes of clarity for all participants and those joining us on Zoom, to give an overview of the process so that we're all on the same page and understand it, the process from today going forward for the proposed rule amendments and how that will play out. And I'd like to call on Mr. Derrickson to give us that overview if he would be so inclined. So Mr. Derrickson, can you do that for us?
Yeah. Can you hear me okay?
Speak up a little. Can you turn your camera on?
Okay, how's that?
It's better.
We're in the process.
In the camera now.
Okay. So there's a number of quite a few steps in moving forward with the rule amendment process. And I've been talking with several different deputy AGs, the Legislative Reference Bureau, to try to sort out exactly what our steps forward are. Right now, before you today are the proposed rule amendments that are we're receiving comments from different agencies, from the public, and we are taking those into consideration at this point. We still need to go to the Legislative Reference Bureau for them to review the rules for formatting. The AG has done a preliminary review and provided some comments, but the AG needs to review as to the form of the rules. We still need to go to the Small Business Regulatory Bureau at DBED to address any impacts to small business, where we'll have to present at a scheduled small business regulatory hearing. Once we've done that, we will be sending on proposed rules and requesting a public hearing, requesting the ability to go to public hearing from the governor, where we'll have to put up the rules in the Hawaii Administrative Rules Processing site called HARPS electronically. And then reviews will be done by Budget and Finance, DBED, other state agencies. We are reaching out to the counties, and we will continue to do that. Once we get an okay to go out to public hearing from the governor, then we will need to set a schedule for hearings, notice them in the papers and electronically, and we'll start receiving testimony that way. We'll have to conduct hearings and prepare minutes of those hearings.
To interject, the public hearings are hearings that can be handled by staff. Commissioners are welcome, but we're not planning for those to be full commission hearings.
Yeah, thank you. I'd probably say that at this point, if there's any questions, this would be a good point for questions.
So 2 points I'd like you to address, Mr. Derrickson. First of all, the overall timeline that you expect. I know I won't hold you to it, but is this a matter of days, weeks, months, or years? Could you clarify?
Yeah, I'm going to let the executive officer field that question.
Thank you, Mr. Chair. This is a process that, based on our experience, could take anywhere from 3 to 6 months.
Okay, so now I have 2 more questions, not just one more. So within that 3 to 6 months, other interested parties, including the state agencies, will have a singular or multiple opportunities to weigh in with suggested edits and changes. Correct or not correct?
That is correct, Mr. Chair. Once we publish the rules on HARPS, they will have an opportunity to testify. The state agencies will have an opportunity to testify. But anytime during the process, they can also provide testimony, and the same for the counties. I mean, we're not anticipating that we will deny anybody the opportunity to testify and submit comments.
Very well. Okay, my final question is, if you can you specifically identify in this process the specific role that the commission has to take, starting with its action that would be expected potentially today in this meeting, and then subsequently along the process before we finalize new rules, the amended rules?
Thank you, Mr. Chair. This commission today, what we're asking for is essentially an adoption of a draft. And during this hearing, further amendments can be made to that draft that staff will place into the rules. Then once we've gone to HARPS, gone out to the public hearings and collected all the information with regard to public testimony, we will come back to the commission to determine whether or not, the commission feels that any or all of those comments should be adopted. If the commission determines that they would like to make substantive changes to the proposed rules, then at that time the process will start all over again. We'll go back out to public hearing, repost on HARPS, and then come back to the commission again for final approval.
Okay, so what I heard was that today you're looking for us to potentially approve the posting of the draft rules. Then the process starts with all of the agencies, et cetera, to do the internal review and suggestion of comments. Eventually, it'll come back to this commission for approval or further amendment. And if on one end of the spectrum, we just accept it as presented and it's approved, we're done. Other end of the spectrum, we could start the process all over and continue to evolve and modify the rules until we reach the point where everybody's happy and we can adopt them. Is that correct?
That is correct, Mr. Chair.
Okay. So I just wanted that clarification for all of our all my fellow commissioners and myself, so we know what we're dealing with today. And so this is not a up and down, we're going to change the rules today. All we're doing is agreeing to move the process forward, in my view. So does any of the commissioners have any questions on what was just explained by Mr. Derrickson and Mr. Orendenker at this time?
Chair Gary Okuda.
Commissioner Okuda, please.
Thank you, Mr. Chair. So my question is to either the executive officer or to Mr. Derrickson. Does our vote, if we were to vote to move the process forward, is that taken in any way to be an endorsement about the in favor of the draft of the rules? In other words, is that to be construed in any way to say that we agree with the substance of the draft of the rules, or is the vote to move this forward simply just to move it forward? And it's not to be interpreted as an endorsement or agreement to any of the draft rules.
Well, that's kind of a convoluted response on our part. There has to be something that the commission adopts as a draft. So that's why this agenda is broken up into two different things, because we have to have a draft that the commission approves that we can put up on the website. So you are, to a certain extent, approving a document, but only as a draft.
Okay, thank you. That answers my question, actually.
Yeah, the way I interpret it, it's a conditional approval, but it's subject to change. And even at this point in time, later in today's hearing, I will be inviting commissioners to make specific motions, if they so choose, for further modifications of the draft that they'd like to see even at this point in time. And that modification could be to add something or to remove something as well. Okay, with Commissioner Carr-Smith, comment?
Thank you. Yes, I think this is a good time for me to ask this question. I was wondering why the staff opted to not consult with the affected agencies prior to this first draft.
Well, first of all, there's plenty of opportunities for the other state agencies to comment. And that was foreseen as a part of the process. With regard to what we're doing today and why, that it kind of feeds into that. We didn't even have anything that we felt that the commission was comfortable with which is why we're holding this hearing, for other agencies to comment. Because this is basically the commission's draft.
Okay, thank you.
Okay.
Brian Lee has a comment.
Commissioner Lee, thank you for pointing that out to me. Commissioner Lee?
Thank you, Chair. I had a question for the executive officer. You know, in a previous meeting, you had mentioned that there would be some admin rules, proposals regarding affordable housing. I didn't see anything there. Can you elaborate?
After discussion with several of the commissioners, we could not come to a consensus as to what that change would look like. So at this point in time, we have not proposed a change to that section. Of course, during the course of the comment process, that could change. But as of this moment, we did not have a consensus on that particular portion of the amendment.
Okay, thank you. You know, I'm just going to state that I'm really uncomfortable with some of the proposals that were made. I feel that it delegates the authority on some of the decisions to one single person or bodies that are not actually prepared to make decisions on some of the issues that should rightly go before us. And if they're able to preempt some decisions, it doesn't give us the opportunity to cross-examine or discuss and question the decision. So I'm going to state that I have some concerns, especially I agree with many of the assertions that were made by the OPSD testimony. Thank you, Chair.
So, Commissioner Lee, I'd like you to, that was a point well taken, and I think there'll be an opportunity for, during today's hearing for you to expand even further a little later in the hearing.
Thank you, Chair.
Thank you. Okay, any other comments before we proceed with public testimony? Commissioner Ohigashi.
I just was wondering what the sequence of events that we're going to take up right now. So we're not discussing any of this part right now. We're going to take public testimony, and then we're going to be able to discuss what we want to discuss.
That's correct. We'll take public testimony, and in fact, the expectation is entities such as OPSD will be welcome to make on the record any comments they want to make as part of public testimony. And once the public testimony is concluded, we'll revert back to the commission for individual comment and suggestions and questions. Does that work for you? To answer your question? Good. Okay. Public testimony. If there are any individuals on Zoom who wish to provide public testimony, please type your name and organization, if applicable, into the Q&A feature. You will be added to the chronological list. We will then call each testifier by name and then promote you to the panel to provide your testimony. When called upon, please turn on your camera and unmute your microphone. After being sworn in, members of the public providing testimony will have 2 minutes to testify. Again, the Q&A feature will only be monitored for signing up for public testimony. All other communications will be addressed or in part of the meeting record communications that can be emailed or on our email at dbed.luc.web@hawaii.gov. The protocol for testifying today by phone only. If you are participating in the Zoom meeting by phone and wish to provide testimony, you may indicate you want to testify by entering, what is that? Print is so small, I can't. Is it a star? Ms. Kwan, what is that? Is that a star?
It's a star, like the pound, not the pound. What is that?
Star key.
Asterisk. That's the word.
Say again, the asterisk?
Asterisk, yes.
Okay, so if you want to testify by phone, enter an asterisk and then 9 on your phone keypad. After entering the asterisk and the 9, A voice prompt will let you know that the host in the meeting has been notified. When recognized, you may unmute yourself by presenting the asterisk and the number 6 on your phone. A voice prompt will let you know that you are unmuted. Once you are finished speaking, please enter an asterisk and the number 6 again to mute yourself. I will now acknowledge any written testimony. Ms. Kwan, has there been any written testimony submitted on the proposed rule amendments?
Yes, Mr. Chair. We received one from Office of Planning on November 13th, one from Commission on Water and Resource Management on November 14th, and this morning we received Department of Agriculture and County of Hawaii. All have been posted to the website.
Thank you. So the Water Resources and the Department of Agriculture, when were those posted?
Water Resource Management was posted yesterday, and this morning we posted Department of Ag and County of Hawaii.
Okay, thank you. And OPSD was posted when?
November 13th.
Thank you. Okay, Ms. Kwan, are there any members of the public at today's meeting that wish to give oral testimony?
Yes, Mr. Chair, we have Cal Chipchase in the room who would wish to give testimony.
Okay, can we promote him to the panel, or is that him in the blue shirt?
That's him in the blue shirt.
Where's his suit and tie? I don't recognize him. Okay, Mr. Chipchase, will you please identify yourself for the record, and then I'll swear you in.
Very good, Chair. Cal Chipchase, not in a suit and tie, considered it, but thought that public testimony should be in an aloha shirt.
Appropriate. Mr. Chipchase, do you swear the testimony you're about to give will be the truth?
Yes, Chair, I do.
Please proceed. You have 2 minutes.
Thank you. Chair, members, I appreciate the opportunity to comment on these rules. I'll be brief because I have a brief amount of time. I'm focused on a number of rule sections. I'll begin with Rule 50, and in particular, the provisions related to requiring a petition to receive prior certification from both the Commission on Water Resource Management and OPSD. Those substantive requirements are also repeated in Rule 90 with respect to conditions and Rule 94 with respect to modifications and amendments. I do not believe that those requirements are lawful. I believe that they are an improper delegation of this body's authority to other agencies. I believe that the delegation exceeds, or the requirement, I should say, to petitioners to include those certifications or approvals exceeds this commission's power as set forth in Chapter 205, in particular Section 17, with respect to the criteria for decision making. I believe that they impose on other agencies powers that those agencies don't have, as set forth in their governing statutes, 174C for the Water Commission and 225M for the Office of Planning and Sustainable Development. I also believe that to the extent the delegation is made, it is currently without any standard for approval. In other words, it does not guard against arbitrary, capricious, or unreasonable denials or approvals for that matter, which again is another legal deficiency. And it fails to consider that those agencies, in particular the Commission on Water Resource Management, have their own processes for approval of well or stream division permits, or in the case of water management area, the approval of existing or new uses. And so it interferes with those separate processes, some of which cannot be engaged in until this body and other land use approving bodies have made their decisions. And so it has that further infirmancy. To the extent those comments are necessary, and indeed they are, there's already a process for them, namely the hearing on the petition for the district boundary amendment, at which time comments from those agencies and indeed testimony related to those issues may be elicited from the agencies and from other representatives. If I may briefly jump to other sections, Section 77, which deals with a change involving the dismissal of petitions. I believe that it is a violation of due process, a A contested case hearing is initiated when the petition is accepted, even if there is no intervention. It should not be subject to dismissal simply because there's a later determination that there's insufficient information. The petitioner has an opportunity to supplement the record. And if the petitioner still does not carry his or her or its burden, the commission can always deny the petition. Doesn't need a separate rule for dismissal. With respect to Rule 95, dealing with SUPs, in particular Section C4, imposes additional limitations on that criteria, which was meant to deal with changes writ broadly in land use conditions and trends. This change would focus it on the particular property at issue. I believe that improperly incorporates something akin to a variance standard, which was not the intent of an SUP, and makes it virtually impossible that an SUP could be granted under those standards. Finally, Chair and members, if I may, there are a number of minor changes. In particular, I'll note that there are a number of deletions of or additions of an E in therefore. In other words, the original word was THEREFOR. The E is added in a number of rule sections that fundamentally changes the meaning of the word. Therefore meaning thus or since with an E. Therefore without an E meaning that is. And so the original draft is correct technically, grammatically. The addition makes the rule incomprehensible. I'll point to Rule 63 as an example of that, but it's found elsewhere. Those conclude my comments, Chair and members, and I appreciate the opportunity.
Thank you, Mr. Chipchase. Commissioners, do you have any questions for Mr. Chipchase?
Chair Gary Okuda.
Commissioner Okuda.
Thank you very much, Mr. Chair. Thank you, Mr. Chipchase. Since you are appearing not as an advocate like you normally do, but as a witness, if you, and Mr. Chair, if you can just indulge me just for a couple minutes, I'd like you, Mr. Chipchase, so that we can place your testimony in context, to first tell us about what your educational background is, and secondly, what your professional experience has been with respect to land use and land use issues.
Yeah, very good, Commissioner. I'd be happy to. I'm an attorney licensed to practice in Hawaii and Iowa, of all random places. I'm a graduate of the University of Hawaii Richardson School of Law. I'm employed at Cade Schutte, where I have been, other than leaves for clerkships, since 2001. I'm not here currently representing any particular client. I'm testifying based on my work in the land use arena and what I see as good process before the LUC and otherwise. I have been practicing in land use and real estate for more than 20 years now, and I have taught land use and real estate as well as writing courses at the University of Hawaii at different times since 2003, published extensively on those subjects as well. Before the LUC, I have appeared on special use permits and on district boundary amendments, as well as designations of important agricultural lands. And I've done so many times over many years now.
And have you spoken at professional seminars or seminars of professional organizations on the topic of land use planning, or related matters?
Yes, Commissioner, I have. I have served both as a moderator and a panel member on a number of land use panels and other panels in different fora, whether they are the annual legal update that I do for the Hawaii Office of Planning Officials, Congress of Planning Officials, or other one-off CLEs. I also host the biannual CLE for the seminar group on sea level rise and climate change.
Okay. And the testimony that you just gave, was that based on your education and experience that you've described?
Yes, Commissioner, it is.
Okay. Can I ask you this process question? Do you agree that the section of the HRS that governs what we are doing is HRS section 91-3, the procedure for adoption, amendment, or repeal of rules?
Yes, Commissioner, I do.
Are you aware of any other section that we should be looking at specifically as far as what procedure we should follow regarding the adoption of rules?
No, Commissioner, I believe this is clearly a rulemaking procedure.
If we moved ahead with the process of adoption of the rules that have been described by staff just immediately prior to your testimony, do you see any potential violation of HRS section 91-3 by the commission?
Not pursuant to the process, Chair. And I'll caveat that with one statement. The commission, of course, has obligations to consider standards that are not specifically set forth in statutes such as Kapa'akai and such as other due process considerations. I wouldn't opine as to whether these rules meet or fail to meet those standards. I offer no opinion one way or the other. But in terms of the rulemaking process that was described at the beginning of the meeting, I believe that captures it correctly. I've chosen to testify today because from a public perspective, this is early in the process. And I believe that getting the rules as right as possible before they go out to broader review and broader comment is the best process, rather than receiving comments, then making changes, and then sending them back out. If we want to be efficient, and I think we all do, I hope that the commission takes this opportunity to make those changes that it deems appropriate before the rules go out to broader comment.
Okay, so you're, and stop me if I'm putting words in your mouth, because that's not my intention.
Of course.
So based on your education and experience, is it your suggestion that we take more input right now with respect to the draft rules, maybe make some changes to the draft, and then engage in the process which staff has explained would be the process going forward?
With respect, that is my recommendation, so that the rules that go out for broader comment best reflect this commission's views as to what the correct rule should be and the most input that the commission can receive at this time in drafting those rules.
Okay, let me kind of ask the reverse question for your opinion. What's the harm to the commission or the public process if we just send the draft rules out as drafted now, take in not only your comment, but other comments that are made, and then make whatever revisions are necessary? I mean, what's the harm in doing that?
Sure. And to be candid, there may not be a harm in doing that. But what I would see as the potential harm, and far greater than the risk the other way, where I see no harm in taking public comment now and making those changes that the commission believes are appropriate now. I think there's no downside to that. The potential downside looking the other way are that if substantive changes are made later in the process, as staff described, the rules will need to resume or reinitiate the process. In other words, it could take much longer if you do it that way. The other problem or potential harm that I see is that although you have opportunities to comment, these things are not always known to all people. I found out about today's opportunity to comment independently from a staff member on the Maui County Council. And so not all people are at all times checking all agendas, which is why the most opportunity to comment, being as broad in your reach, is the best, because it captures the most people, gives them the most opportunities. The third potential problem that I would see is one of inertia. Once you adopt, at least for discussion purposes, a series of rules and then they go out, there's sometimes a reluctance to make changes later on because they occur or happen so late in the process, leading us to restart it, as I talked about earlier. I think it's best to avoid that inertia, to put out what this commission as a body believes today or whenever it does are the best set of rules, the rules it believes should be adopted. That way, comments are focused on not just rules that we all know or believe should change. There's no point in having those discussions, but focused on what this commission believes should be adopted. And that, I believe, presents and produces the best set of rules for final approval.
Okay, final question, and I really promise this is my final question. Based on your experience that you have described in your testimony, what would you suggest the process be and the time frame to maybe try to get the best draft together before it's sent out?
I appreciate that. And What I would say is in the meeting today, I hope the commissioners, and I really actually don't even need to hope, I know that you will take the time to voice your opinions on which rules should change. If I may just digress a moment, I went through a 4-year process with the Maui County Planning Commission to adopt its new SMA and shoreline rules. I was on a working group that participated in small closed discussions and then in many presentations to the commission and to other groups on those rules. It was a very long process and much longer than I think is necessary or could be contemplated here. But because of that process, all voices were heard, all changes were either made or at least considered, and usually compromises were reached. The product, which was just adopted again yesterday, was universally or nearly universally welcomed by the people who are affected by it. In the entire meeting, because there had been so many other meetings, took less than 2 hours, including public testimony and commissioners' comments. That, while painful, was a good process and produced a good series of rules. And so what I would hope today is that that process for the commissioners really begins with them offering their comments, changes, corrections to rules. And if the body is able to reach consensus on those, then make those changes and incorporate them into the rules. If they're not able to get through all of those comments and all of those changes that these commissioners may have, don't just put it out there to get something done. Take the time to continue that process at this stage, at the commission stage, before it goes out for further review.
And I apologize, I do have a follow-up question to what you said.
Of course you do.
Is it your recommendation that working groups be set up by the Land Use Commission?
I don't, in this instance, I don't think that's necessary because the changes that are being proposed on the whole are okay. I focused on from my perspective, they're not significant. They're housekeeping in a lot of ways. They're not things that fundamentally change the process. The portions of the rules that I focused on, I do believe are fundamental changes and potentially damaging or illegal changes. I think that those concerns can be addressed without a working group. That said, if the commission felt that it's more appropriate to have those kinds of groups so that there's broader comment, I certainly don't oppose it. I just, from my perspective, that may not be necessary given the changes that are being considered.
Hey, thank you, Mr. Chief Chase. Thank you, Mr. Chair. No further questions.
Thank you, Commissioner Okuda. Commissioners, any other comments or questions for Mr. Chip Chase? Mr. Chip Chase, I had a couple. We'll have a question and a request. First, the question is, it kind of got my attention as well, the word certified. It appears numerous times in the draft. In lay terms or in legal terms, could you expand what your interpretation of the word or the requirements associated with the word certified is?
I'd be happy to, Chair. Certify would ordinarily mean to verify, to confirm. And I think that is probably the meaning intended here because it's paired with or approve, I believe. Certification or approval is the way it typically means. And so the way I take that to mean in these rules is that a certification or pre-approval of the application, at least with the Water Commission as to the water use and water source as OPSD, other considerations, is necessary before a petition could even be accepted. And so whether we view it as a verification, a certification, or approval, I think we end up at the same place. It is effectively giving those agencies plenary power to withhold a necessary element that this commission deems must be received before we'll even accept a petition for consideration. That plenary power, however we phrase it, I believe goes too far.
Thank you. And my request. First of all, I appreciate you coming forward today to provide oral testimony in this matter. And I personally find that the points you raised to be of personal interest to me as well. And I concur that we want the best product at the end of the process. My request is, if you don't mind, to consider providing written testimony on these points as a follow-up to today's hearing, because I'm concerned that some of what you had to say might be lost in translation or, not consistently interpreted by what you intend to say. And it could only be better interpreted if you provide us a more detailed explanation of your points that you want this commission to consider by providing written testimony. So if you so choose, I would welcome it.
I appreciate the invitation, Chair. I would be happy to.
Thank you so much. Commissioners, anything further for this witness?
Chair Gary Okuda.
Mr. Okuda?
Follow up to the chair's question. How much time would you need to provide written testimony going over your opinions and including what you testified to with respect to the draft rules?
Commissioner, we could have that to the body within a week.
Thank you very much. Thank you, Mr. Chair.
Thank you, Commissioner Okuda. Thank you, Mr. Chip Chase. You are excused.
Thank you, Chair.
Ms. Kwan, is there any other entity or person wishing to provide oral testimony at this time?
Not in the conference room, but we do have on Zoom.
Who do we have on Zoom?
First, we have David Arakawa signed up, and I can promote him to panelist. Just give me a second.
Before you do that, can you tell me how many have signed up?
As of right now, we have 3.
Okay. So let's proceed with Mr. Arakawa, and then we'll take a short break.
Mr. Arakawa, if you could turn on your camera and microphone and give us a mic check.
Testing. This is Dave Arakawa.
Thank you.
Welcome, Mr. Arakawa. Could you please state your name and affiliation for the record, and then I'll swear you in?
Thank you very much, Chair. My name is David Arakawa, and I am representing the Land Use Research Foundation of Hawaii.
Do you swear the testimony you're about to give today will be the truth?
Yes, I do.
Please proceed. You have 2 minutes.
Okay, because I have 2 minutes, I will agree with everything that Cal Chip Chase presented, and I had the same issues with some of those provisions. I would respectfully request a deferral at this time and I would recommend setting up a working group on this matter as was done for the EIS rules. So there's a template for getting this done and getting rules passed and getting it passed quickly, not quickly, but expeditiously. We would suggest a reasonable process that would actually save time. And it was used in the EIS rules, as we said in 2018. It would include stakeholder input before the LUC approves a draft that goes out to public hearing. This would actually save time, because if the fights occur at the small business issue, small business hearings, a small business agency or group hearings, they will have to come back. And then more issues could be raised a second time as it goes to these other places, and they would have to come back. So in the EIS process, we brought in all parties, all relevant parties, and like Mr. Chip Chase said, by the time it went through all the public hearings, everybody had a consensus on the issues that were being presented by OEQC. Those were agreement on housekeeping matters, and we believe these rules were well-meaning, and we'd like to see the housekeeping matters passed, but there are some that cause legal issues. And what happened is they put the contentious issues or issues people objected to on the side and to be worked on later. And unfortunately, COVID and other issues got in the way. This was done at the city and county for other city and county issues also, and the State Building Code Council. So there is a template for all of this. I would point out I'll go over the same issues that Mr. Chip Chase raised. Sorry, I'm rushing because of the time, but I would note that CWORM on 15-1550, the form and contents of the petition and CWORM certification, CWORM only has jurisdiction over certain lands that come within their kuleana. They do not have jurisdiction over other lands, so they cannot, it would be impossible for them to issue a certification or approval for lands outside their jurisdiction, their particular jurisdiction, in some matters. They do represent the state, they do represent state water, but those would be other issues. We share the concerns on all the other sections that were cited.
We lost you. We lost your verbal. We can't hear you any longer. You're back.
Okay, I'm sorry. On the issues relating to OPSD, again, it's one person making a decision, and OPSD is already a mandatory party in the district boundary amendment process, and so it would allow input from other county and state agencies. You know, the Climate Change Commission, DLNR's Climate Change Commission. And finally, I'm not going to go over every single one of the issues he raised or on my list, but because of time, I'll just point out another matter that, well, you know what, that dismissal of the petition, if the commission has insufficient time, that is we believe it would violate due process. But the last thing I'm going to raise because of time, and I would appreciate the opportunity to send written comments, is a well-meaning one. It's the very last thing on your list, and it is deleting the term acts of God, which is a legal term, has been legally litigated, and excusing certain issues with the IAL. I helped draft the IAL law, both versions of the important ag lands law, but deleting that and inserting natural disasters or accidents that are caused without human intervention. That would cause the Lahaina fires to be litigated in front of the Land Use Commission, right? Without human intervention. So there'll be an issue as to that. So it was well-meaning, and it was put in there to address the issue, but it would cause a loss. It would cause, you know, a presentation of all of the parties that are being accused of being involved or responsible for the Lahaina fires in front of your commission, right? So those are some of the issues that you know trouble us, and yeah, and so that's it. And going forward, we think that folks could pass the housekeeping matters. You guys could go out to stakeholder input, starting with the government agencies and with any interested parties, including the petitioners or the holders of district boundary amendment approvals, decision and orders, and ask for their comments. Start with that, government agencies and the public, nonprofit organizations that do appear before you, and get their comments, and maybe start with that. And there may be a number of contentious issues or issues that people don't agree on. Put that on the side, and that would be the subject of a working group, not the whole thing. Thank you.
Very good. Thank you, Mr. Arakawa. Commissioners, any questions for Mr. Arakawa, starting with Commissioner Ohigashi?
Thank you, David. I'm Mr. Arakawa. Sorry, but
aloha.
I'm kind of confused with yours and I guess Chip Chase's testimony, specifically the certification regarding the approval of a water resources management or utilization of water for a specific aquifer. Is that the one you're concerned about, that we should not require that as part of the petition?
Yes, that's one of them, Commissioner Ohigashi. For Maui, there are only certain areas of Maui that come under their certification as groundwater areas, right? You know, groundwater special areas. And so if it's a petition for an area outside of their kuleana jurisdiction on Maui, then what happens? right?
So
You still got to get a certification.
Would you be amenable to having that particular proposed rule change limited only to those areas where they can certify or approve? If they don't, if they don't have jurisdiction, then they're not required to provide that certification?
The answer, Commissioner, is no. And I was just raising one issue of impossibility. The reason why is this might be another impossibility issue, is that to get approval from CRWM, you would need certain other entitlements in effect. So you may need to show that you got confirmation from the Land Use Commission as to the number of units, the number of people, the acreage is covered, and all that. And you may need zoning or whatever it is. And you cannot get that because the LUC is at the beginning of the process. So when you're going to see, there's already a process for CWRM to do this stuff. And that process, again, requires certain prior government approvals. And you're not going to have that, right? So it's a catch-22. So you never get it, right? So I didn't want to raise that. He did that. He raised that. Mr. Chase raised the timing of the process. There's certain timing or certain steps to get approvals for development. And this puts it up front, and you don't have what you need at that time to get that certification. That's a simple way. I should have said it that way. I should have said.
And the last question I'm asking is, I can see the utility in determining any kind of project having available water to prior to getting its okay, or it's seen to, because then we tie up. The tendency is that if we do it after the fact, we tend to tie up agricultural lands that have been into this amounts of this inventory that keeps continuing to be growing, where the LUC has passed, given boundary amendments in the past, and we have a lot of areas where that inventory hasn't been built. So the question that I have for you is then that, assuming that there is an availability to get some indication from the Water Commission or even county water departments as to what, into a petition, what's the harm in requiring simply that they inquire and that they say that these are the resources available? If not,
okay,
go forward with it. What is and in fact, if I was planning a development, wouldn't I be one of the first people that I'd be talking to is the Water Resources Commission, as well as the Departments of Water Supply, see the potential developmental position. So I'm just looking at this as a practical type of petition submittal that we may want to require in some form, but may not be the form that's being proposed. What's your comment on that?
Okay, excellent issue, Commissioner Ohigashi. The answer to that is it's already covered in the existing processes, right? DLNR and CWRM are commenting parties for the EIS, so you're going to get it in the EIS. You're going to get it, and the Departments of Water Supply are commenting parties for the EISs, and the counties are mandatory parties for the Land Use District Boundary Amendment process, and so is OPSD, and OPSD gets comments from all state agencies. So you will have that. Getting that pre-approval is an issue, and we talked about the impossibility, but I asked, Maui is used to this, say, show me the water kind of a thing, right? But I asked Honolulu, how do you guys deal with developments, right? And they say, once the development we comment through the process, but once the development has their entitlements, the State Land Use Commission approval, and the zoning. Then we look at our operations and see, okay, we gotta get our resources up. We gotta drill wells. We gotta do storage. We gotta do transmission lines to serve this area, and they work at it that way. But they cannot commit when at the very first step before this thing goes to Land Use Commission that, oh yeah, we're gonna build these wells. Yeah, we're gonna dig these transmission lines. We're gonna, they cannot do it at that time. So it's a process thing, and it's but it's a kako thing, right? The county departments of water supply need to work with CWRM. And it's not one person or the CWRM board saying, okay, I certify this, right? You need the county water departments involved too. So I think for purposes of this item, maybe we can take it off the list and have the county water departments. I don't know if the county water departments were asked to comment on this, right? This particular one, but I think the Maui County Water Department would say, hey, we like comment on this, right? So so that's the issue on water. And I'm not sure how many developments that the LUC has approved are not proceeding solely because of lack of water. It's more financing, market timing, and things like that. But if there are any developments that are not proceeding, and that's a valid concern of you, Commissioner Ohigashi, then we can work on that. We can work on seeing how the water approvals work for those types of development. And we'd be willing, Land Use Research Foundation would be willing to work with the commission and DLNR on those issues. But we do not know of any projects that are not going forward solely because they don't have this water certification from CWRM. Thank you.
Thank you, Commissioner Kashi. Anything further? Okay, other commissioners? Mr. Arakawa, thank you for coming forward. I would like to echo my request that I made to Mr. Chip Chase, in that you take the time, if you so inclined, to provide written testimony. It's far more helpful in terms, of rulemaking, where we're really looking at the details. And for you to just say you agree with somebody else's testimony really doesn't give us the detailed guidance we need. So I want to give you the opportunity to put your concerns in writing and your suggestions in writing, and the commission will take those in seriously upon receipt. So if you're so inclined, I would welcome those from you.
I will definitely do so, Mr. Chair, and thank you for the opportunity. Thank you, LUC commissioners and staff, for working hard on this, these sets of rules, these draft rules. Thank you.
Okay, thank you very much. So who was that?
Gary Okuda, Chair. If I can ask Mr. Arakawa just one question.
Yes, please proceed. Mr. Okuda.
Mr. Arakawa, how long will it take you to submit written testimony responding to what the chair has asked you to help us with?
I would say best case 2 weeks, right? I would need to talk to I would go out to the stakeholders. I would go out to the Department of Water Supplies. I would go out to OPSD. I would go out to the state agencies that will be affected by this. I already put in a call to all the state agents, to the state agencies that do housing, and I'm asking for their comments. So I think with going out with LURF doing that kind of work and hopefully going to the county planning department. See, all of this could have been done, right, by others, but now I'm doing it, right? And so, so that's the other thing. I think Commissioner raised this already about going to state agencies and county agencies that will be directly affected by these rules. But I would do that, Mr. Okuda, and I may need an extension, and I'll write that letter if I cannot get all of the as many of the major state and county agencies to provide comments on these issues that could affect the stakeholders and the future.
Mr. Arakawa, I don't think we intend you to do our work. Okay, so my question was just how much time you would need to submit your testimony, doing whatever you plan to do with your testimony, but in no way it's to foist on you our duties to do our own due diligence. So you think you can get that done in you can submit your testimony in 2 weeks, or you would need more time?
2 weeks, best case. 1 month would be better. And I apologize if it was if any of my comments were made to seem that I'm doing you guys' job, but I take Land Use Research Foundation seriously. So if I'm going to make comments, I gotta do the research, right? So that's the reason. That's the reason why I gotta talk to all of these state agencies and stakeholders, because I want to make sure that when my comments get presented, they have the necessary research behind it. So thank you, Mr. Okuda. 1 month. I'd ask for a month, please.
Okay, and just so that I treat you as fairly as Mr. Chipchase, can you briefly give your educational and experience with respect to land use matters?
I've been working in land use since 1983, so that's 40 years. I served as the City and County Corporation Counsel for 8 years. I've been a panelist, moderator, guest speaker at numerous land use conferences, shoreline conferences, had a hand in drafting the important ag lands law, school impact fee law, state shoreline laws, the EIS rules, the Ever Water Corporation, set up that supplies water to all of the Ever projects. Even worked on the HAWAI, shoreline management rules. And so a variety of rules. I do serve as a commissioner on the Hawaii Tourism Authority. So I appreciate how Chair runs this meeting and how the rest of you participate in this meeting as a state board and commission. So yeah, 40 years. We've seen processes like this work, like the EIS and what the chair is looking to do. We've seen processes like this work. And even at the State Building Code Council, I think some of the commissioners here may have experience with that passing. Anyway, okay.
And since you served as 8 years as the City and County's Corporation Counsel, the head city attorney, that means you're a law school graduate, correct?
The University of Hawaii School of Law, 1981.
Okay, thank you, Mr. Arakawa. Thank you, Mr. Chair. No further questions.
Thank you. So, Mr. Arakawa, I want to further clarify and agree with comments by Commissioner Okuda. Yeah, my request is that you put your public testimony in writing so that it has more weight and that we better understand your concerns. I'm not asking you to reach out to all the agencies. They'll have their opportunities before us. That's part of our due diligence, it's part of the process. But we would really like you to take your concerns and your suggestions in another level of detail for our consideration, but not to do our work for us. Is that clear?
Yes, clear. Thank you very much.
Okay. So you're excused, Mr. Arakawa. I'm going to take a short break right now. It's 11:11, and we'll reconsume at 11:20. Okay, everyone, we'll go back online. So are we recording the Zoom again?
Yes, Mr. Chair.
Thank you, Ms. Kwan. Ms. Kwan, who is the next person in line to give public testimony?
Next, we have Mary Alice Evans from OPSD.
Oh, welcome. Could you promote Ms. Evans to the panel, please?
She's just been promoted. And Mary Alice, once you get online, can you turn on your camera and microphone? Mary Alice, can you turn on your microphone and camera for testimony?
Thank you. I appreciate that. Chair, do you want me to proceed?
Mary Alice, please state your name and affiliation, and then I'll swear you in and you can proceed.
My name is Mary Alice Evans. I am the Interim Director of the Office of Planning and Sustainable Development.
Do you swear the testimony you're about to give today is the truth?
I do.
And I'd like to grant you additional time beyond the 2 minutes because we are in receipt of your written testimony, which we've taken a look at, and it covers quite a bit. So if you need a little more time, take the time. So please proceed.
Thank you, Chair. Thank you, Commissioners. I won't read our written testimony. Thank you for accepting it, and thank you for allowing me to testify as a public witness. As you will note, we do have concerns, primarily that we haven't had the time, sufficient time, to do more than a very preliminary review of these proposals. That preliminary review did lead us to have some concerns, which we would like to have the opportunity to do more with. And so we are requesting that the Commission defer their approval on this draft and continue the hearing so that we will be able to present you with a more thoughtful, more thorough review of these proposals and be able to serve you and the public better as a result. Thank you, Chair.
Thank you, Ms. Evans. Commissioners, any questions for Ms. Evans? Commissioner Okuda.
Thank you very much, Mr. Chair. Thank you for being present, Ms. Evans. Similar question that I raised to Mr. Chip Chase and Mr. Arakawa. Can you briefly tell us your education and experience with respect to land use planning, or land use matters?
Thank you, Commissioner Okuba. I have a master's in urban and regional planning from the University of Hawaii at Manoa. I have served on the City and County Planning Commission for 5 years, 1 year as its chair. I have worked for the Office of Planning since 1987 at its inception on various matters, not all of them land use. I worked, and I have also served in various appointed positions throughout that time for other departments and the governor's office. I worked under Abe Mitsuda, who was the land use division administrator for 8 years, working on petitions, drafting testimony and position statements to the Land Use Commission. And I have served as the director of the Office of Planning and Sustainable Development since 2019, and then with a break, and now again as interim director.
And this deferral of the hearing that you're asking for, how much time would you like the hearing deferred?
I would leave that up to the Land Use Commission staff as to how much time they believe it might take to get a more thorough presentation to yourselves, to Commission, on the proposals that have been put before you as a draft. I can tell you that from the Office of Planning and Sustainable Development's position, we would need more time to give more than just a preliminary review. We really think that we respect the fact that the Commission wishes to amend its rules. And that gives I think that's a wonderful opportunity, and I want to commend you on undertaking this. And we would love to participate in, all of your processes on this matter. I cannot tell you what your staff may deem to be the proper amount of time.
Yeah, well, if I can just interrupt, I just want to know how much time would you need to submit the type of testimony that you believe would adequately present your position or the position of the Office of Planning? How much time do you need?
Commissioner, I'm wincing because of the sound feedback, not because of your question. I think it would take us. I think it would take us a couple of months.
So 8 weeks, you think you can complete and present testimony that would satisfy the type of information you would want to present to us? 8 weeks?
It's merely a guess. And as you can imagine, as we head into the Thanksgiving holiday, the Christmas holiday, and the New Year's, things do take more time at this time of the year. So, and as you know, our legislature starts up, all of our state agencies, you know, have an interest in how that proceeds. So I think maybe to be safe, maybe a little longer than that, Commissioner.
Can you tell us how many weeks that you believe you would need to be safe?
To be safe. Okay, this is just a guess, but at least 3 months, I think.
3 months, okay.
Yeah.
Okay, but you know, I'm asking that because if you don't give us, or at least I'm only speaking for myself, yeah, I'm only speaking for myself, but if for myself I'm not told a definite date, then I would use my own discretion to determine what would be the definite date. So I'm trying to limit my discretion by giving you the discretion to tell us how much time, because if you say, for example, 1 year, then, you know, I might consider that, and I'm only speaking about myself, unreasonable, and we would go with an earlier date, and, you know, people just going to have to work through the holidays. It's just one of those things. So I don't want to guess, and I'm only speaking for myself. Other people might be okay with a guess, but I would like your best estimate at this time. So your best estimate of when you can give us the type of testimony which would satisfy what you have testified and described to. What is your best estimate of the amount of additional time you need?
I'm going to stick with 3 months, Commissioner.
Okay, thank you very much. Thank you, Mr. Chair. No further questions.
Okay. Other commissioners, Commissioner Lee?
Thank you, Chair. Aloha, Director Evans. I've had the pleasure of serving with you on other boards, but please don't hold that against her. My question has to do with what your thoughts are, since you've served on so many different departments, on how often admin rules are updated in general, and how long it usually takes in your experience. Thank you.
I've drafted rules. I've supervised the process of getting rules adopted over for different, none for the Land Use Commission, obviously, but for the Office of Planning and for DAGs and for other programs. I do think that initial draft takes some time and thought, but I think the process of getting input from the stakeholders is probably the one that should take even longer. And so I would defer to the way OAQC did their rule amendment process. As I think you may know, that the former OAQC staff is now part of the Office of Planning and Sustainable Development. And I think we could provide or describe the process that they followed for the commissioners' information. And that we could do, I believe, fairly quickly, I think within several weeks.
Just a follow-up. Would it be fair to say that rules are amended infrequently, years, and that the process from beginning to end probably takes somewhere between 1 to 3 years in general. Would that be a fair statement?
That would. It's deliberately designed to take longer than it takes to pass a law or amend a law, because the decision-making body is not an elected, comprised of elected officials. So there are more safeguards and checks and balances in the rule drafting and adoption process than there are in getting the legislature or the city councils to change their statutes or ordinances. So yes, it should take a long time for the reason of providing the public and stakeholders adequate opportunity to inform you of the impacts of proposed changes.
And finally, Chair, Director Evans, you've alluded to this, but administrative rules have the force of law. Is that yes, correct? Thank you, Chair. Thank you, Director.
Thank you. Other commissioners? So I have a couple items, Director Evans, that if you permit me to proceed, I'd like you to, my understanding of the process as was described at the outset of today's meeting was that we're asked to put forth a draft of proposed rules, and then the process would unfold with stakeholders given multiple opportunities to weigh in on those draft rules. What I'm hearing from, and I don't want to put words in your mouth, so I'm going to ask you to comment on this. What I'm hearing from you, as well as in your written testimony, is that you want to put more time in up front to make suggestions to the commission and commission staff about changes to the proposed draft prior to the commission acting on that draft. Could you expand on that?
Yes, Chair. So draft rules are not normally submitted to the HARPS process to request governor's approval to go out to public hearing until the draft is a final draft, that the body that is adopting them as a final draft is perfectly satisfied with the content of those proposed rules. And so that usually involves additional time prior to submitting them to the governor's office for governor's approval to go out for public hearing. The process that you described, Chair, would shift all of that input to the commission after you've gone to the governor and asked to go out to public hearing. And respectfully, I think the stakeholders and the Office of Planning and Sustainable Development would like the opportunity to provide you with our best suggestions prior to you adopting a final draft to go to the governor.
Thank you. Understood. So now that leads directly into my second question, or is that what we have on record by virtue of your written testimony is an expression of your concerns. Mm-hmm. It stops short of remedies for your concerns or specific language that would address your concerns. And just now you made the reference to, I think the term you used was best suggestions. Can you elaborate what you mean by best suggestions and whether they would go further than just be a restatement of your concerns, and whether those best suggestions would actually include specific language addressing those concerns that you would recommend that we consider for adoption in the draft that we would publish?
Yes, Chair, that is exactly what I'm saying. We didn't have sufficient time to look for better ways to achieve your goals. and make suggestions for possibly other areas that you might want to consider with language that might accomplish that, should you choose to go in that direction. Yeah, stating concerns doesn't give you our best
suggestions.
Yes. Well, it just gives you kind of a, that's why I'd like to say that our written testimony, I hope, is not the last testimony that we're able to provide to you. It's our way of saying that we would like you to defer the decision to submit this to the governor for approval to go out for public hearing at this time, and hold at least 1 or 2 more hearings where you put this on your agenda and take in more testimony, including ours.
So to tie a bow on this, what I'm hearing from you is that, and tell me if I'm interpreting this correctly or incorrectly, that if we defer for nominally 3 months before this commission would take up entertain a motion for adoption of the draft rules, that within that 3-month time frame, OPSD would submit to this commission in writing its concerns and suggested resolution of those concerns in black and white.
Yes, sir.
Thank you. Commissioners, any further questions for Commissioner Ohigashi?
Yeah, my question is more substantive, I guess. 15-15-50C27. I think you commented regarding the certification or approval by the State Office of Planning and Sustainable Development State Sustainability Coordinator that all issues identified in et cetera, be adequately addressed, be included as part of the petition. Is it your position that that should not be done? Or is it your position that that is not possible to be done?
I'm not sure I understand your question, Commissioner Ohigashi. Can you, my apologies. Can you?
One of the complaints that the past 2 testifiers have indicated was obtain certain certifications by amending petition process to include certain certifications and approvals. One of them is from the State Office of Planning and Sustainable Development Sustainability Coordinator, say that, yeah, they've met all these requirements in there. Is that something that your department agrees with or disagrees with?
I think we see that there is a county function for looking at drainage plans, and that when we go out to get comments on petitions, we do ask the county planning departments to circulate to their other involved departments and get those comments back. And those comments come to you with, I think, from the department that will be approving a drainage plan, should you, in your wisdom, decide to grant a district boundary amendment.
Maybe you don't understand my question, Director Evans. I'm just asking about this requirement that we're trying to, one of the rules proposed changes was to require a certification from your office, the sustainability coordinator, that the sustainability goals have been met, adequately addressing climate regarding to climate adaptation and mitigation measures identified. That's one of the complaints, I think, of the last 2 testifiers. My question to you is, wouldn't that be something that your department would normally do anyway when it reviews any petition prior to coming to us?
We review that, absolutely. We do not certify it because sustainability does not have fixed standards or criteria. It is a moving target that we are all learning about as we go along to try to.
So is it your testimony then that is not necessary because it is the Land Use Commission's job to determine if the sustainability goals are?
We will provide you with the information on that issue, but
You're not answering my question, Director Evans. My question is that our job to decide whether or not the sustainability goals have been met, or is it your Office of Sustainability coordinator's job to tell us, hey, we believe that it's been met?
It's our job to tell you whether we believe that the proposed development is sustainable. It's your job to decide whether your criteria have been met.
So would it be then better, one of the modifications could be that a requirement within the petition that they have some statement from the department, some pre-statement from the department, because from what I understand is that your department reviews all petitions prior to them being filed for its completeness. And one of the things that should be included in that petition is an evaluation or statement from the department, regarding the goals of sustainability. Wouldn't that be something that our rules should include, that we have something from your department certifying that they have reviewed these and find and of the opinion that yes, it meets the goals?
We already do that, but that's different from certifying something that doesn't have standards for certification.
You're missing my question again, Director. My question is, wouldn't it be better to have it as a condition, as a petition requirement, to have some kind of input concerning the specific area included as part of the petition, so there and that they be forced to go to you and create a document that says that your opinion, if you said it, that's within your kuleana, that they have met all the sustainability goals. Wouldn't that be a proper petition requirement?
I don't believe so, but it is it's the commission's decision on it. I think that your opinion doesn't technically match up with your testimony, but that is my opinion. I'm going to answer my question. Thank you.
Thank you, Commissioner Oigashi. Other commissioners, any questions further? Thank you, Director Evans, for coming forward and for your written testimony.
Thank you.
Ms. Kwan, who is next on the list?
Third testimony will be from Zendo Kern from Hawaii County. Give me 1 minute to promote him.
Thank you.
Aloha.
Aloha. Can you give us a mic check?
Mic check.
Please state your name in full for the record and your affiliation, and then I'll swear you in.
Zendo Kern, Planning Director for Hawaii County.
Thank you, Mr. Kern. Is the testimony you're about to give to be the truth?
Yes.
Please proceed.
Excellent. Thank you very much for the opportunity to testify. Thank you, members of the Commission, for your service. I have been in land use and building of homes, affordable homes, for about 25 years. Born and raised here on the Big Island, and had the unique opportunity to serve as a planning commissioner, chair for 2 years, serve as a county council member, chairman of the planning committee, serve on the water board, and have worked extensively in the private sector. And I've had the opportunity to serve as planning director for 3 years at this point in time. Our request, excuse me, our testimony is similar to other testifiers that you've seen from Mr. Chip Chase to Mr. Arakawa to Director Evans. Our request is that we take a little bit more time on this and give us a little more time to respond in writing. I apologize that we weren't able to give a detailed response in writing. I do not want to come with complaints. I'd like to come with suggestions and opportunities to move forward together and work together and potential solutions within that. Having 5 working days to really review it is not enough time while we're running an office and a lot of other work that we're doing. The concern that I would have about moving this forward without taking the time for the input up front is that there's a perception, and that perception is that those rules already have an endorsement of the commission, which begins to change the public understanding of that as it moves forward. Knowing that there will be adjustments and potential changes as it moves forward, I think it makes sense to take that time now and get that foundation as right as it can be. There's a saying in land use, I think we've all heard it. Sometimes we need to go slow to go fast. And I think in this case, this is one of those opportunities to look at it, to review it, perfect it a little bit now with some input, some valuable input, and then move that forward. I fear that not taking that time will create that perception. And so we respectfully request some time to respond. I can respond in writing in details about our concerns with positive suggestions to moving forward, and I can make that work within the time frame that any of the other testifiers have given. Prefer to coincide with Chair Evans' time frame, ideally with the holiday season coming up, and we are understaffed, and we do have a lot of work that we're doing. I don't want to get into any of the substantive detail again, because we didn't have the absolute time to really get into that. And I'd like to be really to the point and valuable within that. I'm really happy to answer any questions, and again, humbly, respectfully request additional time to engage in this, and really that concept of working together. That's what we'd like to be able to do.
Thank you very much for your testimony. Commissioners, any questions for Mr. Zendo-Kern? Commissioner Lee.
Thank you, Chair. Director Kern, were you asked for any ideas on your own for administrative rules proposals that, in your eyes, might improve the operations of the Land Use Commission?
Not to my knowledge. I get a tremendous amount of emails. I did have my staff check if we had been reached out to prior to this draft from LUC staff to opine on it. We could not find anything. So to the best of my knowledge, we were not engaged early on in the conversation.
And follow-up question, if you were given some time, do you think that there might be some ideas that you or your department might propose?
Absolutely. Our goal, given the time, would be to go through. There's a handful of areas that we have concern that's similar to what others have said, and what we'd like to do is propose what our concern is, and then what we would propose as a reasonable solution to achieve the end result. What we're trying to do here, that would be our goal. And yes, we can do that.
Thank you, Director. Thank you, Chair.
Thank you, Commissioner Lee. Commissioner Okuda, did I see your hand up?
Yes, thank you very much, Mr. Chair. Mr. Kearns, thank you for your testimony. Similar to the other questions I asked of the other testifiers, you did give some background of your professional experience and experience with respect to land use. Not that it's really necessary to qualify you as an expert, but do you have any educational background with respect to land use or urban planning?
So my pathway to get here has been very different than most people. I grew up deep in the jungle of Puna, and I did not have the opportunity to go to school. I went to the School of Hard Knocks, took night classes, and have learned from being in the field, operating, doing, and serving. And through that, I had become very efficient and effective at what we do for over 25 years, whether it's building, whether it's land use on a border commission, or serving in the serving as a county council member.
Okay, I was going to follow up on that. And by the way, one of the most intelligent people, smartest people I ever knew was my uncle Yasuji Takazaki, who only had a 3rd grade education, but built up Carmelo Orchids Incorporated, which I believe is still the 2nd largest exporters of potted orchids, and they operate off the Hamakua coast. He's the one who told me I was not fit to be a farmer, go to law school instead. But I wanted to follow up with that. You served on the county council, is that correct?
I did. I served on the county council and I chaired the planning committee. And prior to that, I served on the planning commission for 3 years, chaired for 2 years, and never missed a meeting of the planning commission over 3 years.
Can you give us approximate dates when you had the service or you gave this service on the council and the commission?
Sure. Yeah. County Planning Commission was first. That was around 2008, 2007, 8, and then moved into County Council in 2012. I ended up serving 1 term there. I decided not to run again due to personal reasons, and then went back into private practice of doing land use planning and consulting.
Okay, and your private practice involving land use planning and consulting, what period of time did that cover approximately?
So that was extensive. After county council, I focused on that quite a bit, all the way up into the point of becoming planning director. Prior to that, it was more engagement in the development side of it, building homes, doing entitlements, but not for clients, more for my own company. And so we did a lot of affordable homes and some commercial projects. So it's kind of sandwiched on the front side of our own projects, government, and then after that it was 2014 to 2020, helping clients navigate through the process of rezone, special permits, use permits, variances, subdivisions. Had a small firm of around 5 people.
Okay, and you believe that your best estimate, not using the word guess, but best estimate is in 3 months you could give us the type of input that you just described in your testimony. Is that correct?
Yes, that would be most ideal. And yes, we would be able to provide that. Absolutely.
Thank you very much, Mr. Kearns. Thank you, Mr. Chair. No further questions.
Thank you. Any further questions for Director Kearns? Thank you. You are excused. Appreciate you coming forward.
Thank you all. Aloha.
Aloha. So it is currently 11:55, and we do have a continuation of some noise feedback issues in the room there in Oahu. So we're going to take a lunch break now and give our staff the opportunity to fix those problems and grab a bite. And we'll reconvene at 12:45. Does that work for everybody? Okay, we're adjourned at 12:45 and then we'll come back.
It is 12:45.
Are we on the record recording?
Yes, sir.
Okay, I'll call this meeting back into order. When we left off, we had just concluded our third witness for public testimony. Ms. Kwan, is there any additional people that have been waiting for public testimony?
Nobody has entered in the Q&A that they wish to give testimony.
Okay, so just the way we will proceed from here, I'm going to give staff, LUC staff, an opportunity to weigh in and comment on the testimony that we've had already today. And then I will give a second chance for anyone wishing to provide testimony on a public testimony before the commission. And then the commission will make on its own deliberate and see if it wants to move, how it wants to move forward. So with that, I think if there's nobody else waiting to testify in the first round of public testimony, I'll throw it to LUC staff, Commissioner, Executive Director, Mr. Orendanker. Did you want to, you or Mr. Erickson want to follow up with anything you've heard so far?
Thank you, Mr. Chair. I'd like to address the commission with regard to a number of things. First of all, I'd like to point out that unlike what happened with OEQC, which was a major rewrite of their rules, this rule change amendment was not an attempt to make major changes to how or what we do. 90% or more of the changes that we are suggesting were either to conform the rules to the Office of Information Practices requirements, or to make changes that resulted from recent past 2 years or so, Hawaii Supreme Court cases and federal cases. The AGs have been concerned that we have not made changes to our rules to conform to those cases. And that was how this started out. The two proposed amendments that seem to be of real concern are the ones with regard to certification or whatever, or our acceptance by the Commission on Water Resource Management. There's actually 4 paragraphs. And the changes with regard to having the Office of Sustainability comment. First of all, we would like to point out that contrary to Director Evans' testimony, that one of the reasons that we put in that language with regard to the sustainability coordinator was as a result of a recent hearing that we had on the cemetery in Kaneohe, wherein the county's minimum requirements do not or have not changed in answer to the changing climate problems that we're having and the increased need for drainage and resources and runoff. Be that as it may, the rest of the changes, as I said, are almost innocuous. We don't have any choice with regard to the changes that we made that arise from the Supreme Court cases and the federal cases. We did not engage with the community and do charrettes prior because those 2 changes that we were making, as Commissioner Ohigashi was pointing out in his line of questioning, we thought that that should have been done by OPSD anyway. Be that as it may, where we don't believe that those are necessary for our continued operation. And my suggestion would be that we remove those from the proposed rule amendments at this time. I would also suggest that we adopt some of Cal Chipchase's testimony with regard to the definitions of therefore and therefore, and revert back to the original language. That being said, it is up to this commission on how they want to proceed. The broader reach in our mind was to take place when we posted the rules and went out for public testimony. I agree with David Arakawa completely that, which is, as you may know, interesting, but that the community does not monitor our website. The community doesn't know, all the time what we're doing, and that public outreach efforts would get more people involved. However, we can't do that until we get authorization to hold public hearings, because we don't know who to reach out to. We do give notice to everyone who is signed up for personal notices with regard to our meetings and what we're discussing, and they get a copy of the agenda, but we did not get any response from anyone with regard to that. So, as I say, staff felt the purpose of this hearing was to begin the dialogue. If the commission feels that now is not the time to move forward with these rules, that's fine. I would suggest, however, that one of the possible solutions is to remove that language, those 4 paragraphs with regard to the Office of Sustainability and the Commission on Resource Management, just so we can conform our rules to current law pursuant to my discussions with the AG. And I'm available for any questions you may have.
Commissioners, any questions or comments to staff? Commissioner Lee.
Thank you, Chair. I appreciate the comments by the executive director and commend him for trying to comport the rules with recent legal developments. I do have some questions, however. I would like to know, when were the last 2 times that the LUC amended its rules, and how long did it take for those last 2 times?
Scott, do you remember the dates?
Yeah, this is Scott Derrickson. The last time we amended our rules was in 2019. That process was about 8 months and began earlier in 2018.
And then the time before that, do you have that information?
I know we did one minor change that was a change that the executive officer was able to make a change to. But when you're talking about more significant changes, I believe it was about 2014, 2015.
Yeah, in 2014, we actually published our rules with regard to important agricultural land designations. That had not been done, even though the law had been in effect for some time. And that took about 8 months, 8 to 10 months as well. In both of those processes, what we did was we published the rules, gave public and all the state agencies the same opportunity to testify on what they thought about the rule amendments, make suggested changes. After we had been authorized to go out to public hearing, we then held hearings on every island before we brought them back to the commission and obtained testimony from it, including Molokai and Lanai, before we came back. And that was what we intended to do this time, to a certain extent, depending on how much funds we have available. Lanai and Molokai have become problematic at this point. This is what we're doing right now is no different than what we've done before. You know, we published a set of rules and gave everybody the opportunity to comment on them at the same time, including the public. Except for 2014, when we did the IAL rules, none of the rule changes that we've been involved in since have been anything that would amount to what I would call a major rewrite of our rules.
Okay, thank you. I don't think there was any malice intended, and I like the idea of separating some of the less controversial proposals. So I'd like to see a better breakdown in writing of how you see that. But I was concerned with some of OPSD's comments that they're not able or to do some of the things that were proposed. And also at the last meeting, the chair did advise to reach out to the counties, planning departments or planning directors, to see if there were any ideas, since we're going to go through this, to incorporate some of those ideas that we may or may not do that, but I thought that was a good idea. And I think we heard today, at least from the Big Island, and I'm pretty sure on Honolulu, they didn't either have the time or were not aware of that opportunity. And so I'd like to see more outreach on that. And I'll just briefly share screen. I know this is dangerous, but this is a 4-page procedure on how admin rules are updated. And so I'm really impressed that you were able to do anything in 6 to 8 months. So, I think you should be commended for that speed and efficiency. But you see, it's a really detailed process. And I'd hate to have to go through that all over again if we didn't do a little bit more thought from the beginning. So thank you, Chair.
Thank you, Commissioner.
I would just like to point out that I understand what you're saying, and that's why I'm proposing to remove those 4 paragraphs at this time. The rest of the changes It doesn't matter. Well, I shouldn't say it doesn't matter, but we could get a lot of testimony on that, but we won't be able to make any significant changes because the language was given to us by the AGs and it's pursuant to law. So, thank you.
Okay. Any other questions or comments for the staff at this time? Okay, hearing none. Commissioner Carr-Smith.
Sorry, I figured that others would have questions, so I was waiting. Yeah, I too was disappointed that it seems as though the counties were not contacted since we specifically asked for that. And I just don't feel like it's appropriate to pull parts out of this, what is being proposed, when there's still so many people and so much testimony that says that there needs to be more outreach to the stakeholders involved. So I tend to feel that a deferral is appropriate, and we spend more time getting it right the first time for the first draft.
Thank you, Commissioner. Anyone else want to comment this time? But Commissioner Ohigashi.
And just gathering my thoughts. First thing I like to say is this, that I appreciate everybody's concern that that they want outreach and everything like that. However, the outreach to the counties does not concern these two particular requirements. Two particular requirements are requirements that we are looking to do to state agencies. We don't, for example, on Maui, my understanding is that we have something like 8 million, if they were to develop what the Land Use Commission has authorized, we would use up to about 8 million gallons per day water in the central area, when the sustainable yield is probably about 5. It makes sense that we ask our own state agency to say it's okay to further development in that area. Everybody's talking about Maui this, Maui that, but I'm the one that lives here, and I see that happening. So it makes sense. That change makes sense. The other change came about, I remember that case. It was a cemetery case that we had. They didn't design for the proper amount of drainage flow, and we're asking that our own OSPD look at that and tell us, does it meet sustainable? Those are the two controversial parts. Nothing to do with the counties. I fail to see what that argument is all about. I can understand that you want input from the counties regarding some of the other issues that may have been brought, and that's fine. But most of the changes were related to requirements that the AG is asking us to. So, what does this tell me? This tells me that two things. One is that I think that everybody wants to discuss this further, especially those two issues, which is fine with me because I'm a short timer. I believe that you folks have all the right to discuss as much as you like. However, the changes that are required to be made, that the AG is forcing to are through either through Supreme Court action that requires us to make those changes. And if we're not gonna do it, we're gonna be caught in a situation where we aren't able to essentially comply or send a signal out that we are complying with this. The last thing I'd like to say is that I'm disappointed in one aspect. I recall that there was an objection in a case as to us designating individuals as expert testimony because it's not specific in the rules. And I believe that if we should go forward, we should formulate a rule that allows us to designate or specifically designate expert witnesses in contested case hearings or in any case hearings where they were asked to designate. That's my comments. I agree with Dan. If you also want to discuss those controversial, that's fine with me. I think we should bifurcate. I think we should move on with the required amendments in this matter.
Thank you, Commissioner Ogashi. I had one follow-up question to Mr. Orendanker based on Lee's questions and comments. If we bifurcate and leave those two issues out as you suggest as possible, when are those addressed? Do we wait for another rulemaking down the road or what?
Yes, Chair, that would be what would happen. In discussions with one of the testifiers, Cal Chipchase, he pointed out that there's some complexity to those issues, especially with regard to Commission on Water Resource Management. The rule with regard to the sustainability coordinator is internal, but it would take some time to hash out that language. And it's not something that prevents us from moving forward. I mean, we don't really even need that rule at all, to be honest with you. It can be handled through questioning by commissioners to OPSD as to whether or not they have talked to Commission on Water Resource Management and requesting that if they have not, that they should. So we don't really need that change. We actually don't even need the sustainability coordinator change. That could be handled in the same manner. To a certain extent, those two rule amendments were proposed to flag the issues, so to speak, with regard to OPSD's participation. I would also like to point out that we intended, and I think I said it at the first hearing when we were questioned with regard to having the county's input, that it is our belief that the current process as it's set up was designed to have the county's participation before it went out to public. We needed but we need to be able to post that for them to have access to it. Actually, they have access to it on our website, but they don't look at it. I did talk to the head of DPP on Oahu, and she did not take issue with what we were proposing, other than those two controversial ones where she said she'd have to look at them a little bit more. And I did talk to Kauai. Maui is problematic, as you may or may not know. The head of DPP for Maui's house was burned down in the Lahaina fire, so she did not respond to my phone calls right away. As I said, you know, outside of those two things, we really don't have choices with no matter how people testify with regard to modification of the rest of them. So the process, without those two changes, the process is fairly simple. You know, we go out to public testimony because that's part of the process, and maybe there's a slight tweak of the language as a result. But those other changes, this is what the AG is telling us.
Commissioner Lee.
Thank you, Chair. Mr. Orodenker, don't we have to follow the law anyway? Wouldn't the findings of fact and conclusions of law take care of what legal regulations that we would have to follow?
Yes or no. Yes, to the extent that we do have to follow current case law, but no with regard to the language in our rules. A couple of the cases that were litigated were actually litigated on what our rules say and whether or not they comport to constitutional and due process issues and the rest. And that is why we're being urged by the AG to make those changes.
Chair Gary Okuda.
So, Mr. Okuda, if I may, I'd like to give, we're kind of going into general discussion and Q&A. And I want to go there, but I want to give the community a second round of opportunity to testify if they want to before we go any further on general discussion among commissioners and staff. Can you hold your question or do you want to take it now?
If you don't mind, Chair, this is a specific question in reference to what the executive officer just said. So
okay.
Asking for a factor response.
Please proceed.
Mr. Orodenker, the direction that you testified to or stated coming from the Attorney General, is that in writing or is it oral or what form is it in?
I have a string of emails.
Okay. I don't know what the answer is regarding that. Is that something that should be made public or is that considered internal attorney-client advice? I don't know. I just raised that. The second question is the two items, and I apologize for being blunt, but is one of the motivations of the items which are being described as controversial because there's a belief by you or your staff, and I don't want to put words in your mouth, that Office of Planning is not giving the input that you believe is necessary?
Yes, Commissioner.
Okay, and so when you say we can handle it by questions, you mean that, well, if we don't have the rule, basically commissioners can ask or insist that the Office of Planning respond to those questions being raised?
Yeah, we can do it that way. The reason that we decided that it might be a good idea to put them in the rules is so that we didn't have to delay petitions and proceedings. Because if OPSD is not prepared with responses from both of those entities, then we have to continue the hearings to a later date until they have done that and come back with information. So a lot of our intention was to actually benefit the petitioners by making sure the information was available so that we could get through a hearing in one day.
Okay, thank you for responses. Thank you, Mr. Chair.
Thank you, Commissioner. Thank you, Mr. Orodenker. Does that conclude your comment you want to make, Mr. Orodenker?
Yes, at this time, Chair.
Very well. So at this time, I want to give the members of the public a second opportunity to offer testimony, public testimony. Ms. Kwan, has anybody indicated that they'd like to give additional testimony at this time?
Nobody has used the Q&A to indicate they wish to give testimony at this time.
And nobody's in the room?
And nobody's in the room but staff and commission.
Okay, very well. So let the record show that the opportunity was offered and nobody took advantage of it. So at this time, Commission, we're open for continuation of discussion on this matter based on the information that has been presented in advance and written testimony provided on it to us in advance. as well as any testimony that has been heard today. So let me throw it open to commissioners for comment. Commissioner Yamani.
Mr. Chair, thank you, Mr. Chair. Can everyone hear me okay?
Yeah.
For the staff, Mr. Arendenker, if what I'm hearing you're saying is you're willing to take out the proposed rule amendment that was supposedly controversial or people had issues with, what's the process then? Do you need to now redraft the amendment and repost, and then do we have to go through this process again where we have to meet and make a decision? What happens then?
What we would do is we would meet with all the stakeholders, including the counties, the AGs, the Hawaiian community, Commission on Water Resource Management, and Sustainability Branch of OPSD, as well as OPSD itself, and work through what kind of language makes sense and whether or not the amendments even are needed or necessary. Excuse me. Once we did that, then we would come back with new proposed language to do another amendment. We wouldn't do that quickly. I mean, you're talking about a year, maybe even longer, before we would even have language that everybody was happy with. And then we would have to repeat this process. It's my belief that if we defer this matter so that we can work with the stakeholders to develop language that everybody would be satisfied with, we're deferring all of the changes for about a year.
And then on the other scenario where how you propose to take out the language that affected the other state jurisdictions and just leave the so-called house cleaning on the way you propose, how would that work? Would you then, because right now the rule amendment that's proposed and on the table is everything. Would that have to be also amended to take those out, or would there be a?
No, we would leave the rule amendments, the proposed rule amendments, in that we were instructed to make by the attorney generals, and we would leave the rule amendments in, which are fairly minor, with regard to the Office of Information Practices direction on filings being ADA compliant, and move forward to posting and to subsequent public hearing.
So a motion would have to be specific to kind of spell that instance out, where to post just the more house cleaning things and leave out the more substantive amendments. Is that correct?
That is correct. And I wouldn't characterize it that way. It's more like the mandatory changes versus the discretionary changes.
Okay, thank you. No more questions, Mr. Chair.
Thank you. Others, commissioners, comments? So the chair has a few comments. Personally, I take these amendments pretty seriously, and I commend the staff for taking the time to go through it line by line and clean up the housekeeping events, and also to conform with what I'll call informal suggestions by email from the Attorney General to clean up and comport our rules to where they should be, and also to try to address some issues of significance involving the participation of critical state agencies in our process. I, for one, have been concerned in recent months and in recent hearings that despite the fact that opportunity is given to state agencies, they've been, in my view, missing in action on many cases before us. So I interpreted some of what Mr. Orendanker refers to as the more controversial discretionary amendments to be a vehicle by which we would get the state more engaged in our process on a proactive basis by putting some obligations on them. I think that's a noble effort, and I think it's welcome in many respects. But at the same time, we're also hearing from these agencies in writing and in testimony today, directly and indirectly, that it's problematic for them as currently drafted. All of which, and there's 4 of them, testified before us today in a consistent way in which they're asking for time. Time to actually not just complain and raise concerns, but to offer bona fide suggestive language that would remedy their concerns, and at the same time give us an opportunity to get them encouraged to commit to language that would get them involved and support in LUC processes. So I don't really understand the timelines associated with the 2 scenarios that were just explained to Commissioner Yamane. But it sounds to me on the surface that one is, let's just go take care of the stuff we got to take care of to make it comport with good housekeeping and suggested language by the Attorney General. And we'll go through this 8-month process to clean that up. But meanwhile, the things that are really important to us, we're going to kick that can down the road a bit and deal with them later. I, for one, think that it's important that we raise these issues now and we try to deal with them now. And obviously, staff has put out some language that bothers some people. There's nothing wrong with bothering some people in my mind. It gets them, calls them to action. So we have heard that from all 4 of these entities, a willingness to translate their concerns into suggested remedies and to suggested language that would work for them. I think that's a worthwhile process. And if they don't follow through and do that, then it's shame on them and we can move forward with staff on our own. So I, for one, would actually, if it's the sentiment of this commission and majority, I would join them in entertaining a wait and see, a period that we would defer for a short period to give these parties an opportunity to work with staff to get a more complete amendment rather than just deal with the obligatory ones up front. So I'm interested in what other commissioners feel on those points.
Chair.
Who's this? Okuda?
Gary Okuda.
Yes.
Yes. Thank you, Mr. Chair. I make a motion that this matter be deferred for a period of 3 calendar months. Is that 12 weeks, however it wants to be calculated? And if there's a second to my motion and if there's discussion, I'll state my reasons why I'm making the motion.
This is Commissioner Lee. I'll second that.
So the motion to defer this matter for 3 months has been made by Commissioner Okuda and seconded by Commissioner Lee. And I'll go back to Commissioner Okuda, who promised to explain why he made the motion.
Mr. Chair, this is Gary Okuda. I incorporate, as they say, by reference, the reasons and the statements you made. Let me also add to the statements that you made. The witnesses that testified, particularly the Office of State Planning, even though unfortunately required some prodding to get a clear response, basically says that their best estimate to respond and give us specific information or specific responses would be 3 months. So I believe there's no downside risk in giving them the 3 months which they stated is the best estimate of time they would need to respond. Number two, 3 months gives even more time to the time that, for example, Mr. Chip Chase stated that he would need to provide supplemental written testimony. So I believe 3 months is a reasonable time based on the witness's own testimony. Secondly, the fact that responses will be provided to us in writing will allow us to see in black and white exactly what the position of each party or testifier is. No more wishy-washy stuff. And if a party or a person submitting testimony desires just to give us vague and ambiguous or non-committal types of testimony or responses, then we will weigh and make a decision based on that. And so I think this will bring clarity to the process, and 3 months is not that much of a long time. I share the chair's concern about certain parties. Let me be blunt. The Office of State Planning and Sustainable Development being more than missing in action. I believe at one hearing, one of their representatives described their position as, in some cases, they're the watchdog, and in some cases, they just compile information. They have a public trust, too, to protect things that are required to be protected under the public trust doctrine. And they have a obligation. In fact, I believe it's a fiduciary obligation to look into pending cases and take a position and be the watchdog. I'm not saying watchdog means to oppose everything that comes before the commission, but watchdog means to sniff around and see if there's some type of environmental bomb ticking away, which can affect the items that are required by the Constitution to be protected, such as Hawaiian cultural practices and resources. So that's the reason for my motion.
Thank you, Commissioner. Commissioner Lee, you want to speak to your second?
Not really, but since you gave me the opportunity, I'm troubled by the concern from the departments. I think it's a good thing. What I would like to see, though, is in the meantime, if the executive director could show us in writing what is considered controversial versus non-controversial. That way, maybe we'll have a leg up in case later on we decide that, that's the route we're going to take. But, so as we don't waste any time, it'd be good to have the ability to see that in writing, because sometimes one person's idea of controversial may not be another person's idea. Thank you, Chair.
Thank you. Commissioners, any other comments on the motion? Commissioner Ohigashi.
I'm going to reluctantly vote aye. The reason why I'm going to reluctantly vote aye is that I agree with your statement that we are taking the things that appear that we're trying to do the things that we should be doing and kicking the real problems down the road. And I hope everybody remembers that when we come back 3 months from now, and when all these people who complained are fully allowed to make a statement and solutions are presented, that we go forward with those solutions, rather than saying, oh, well, it's still controversial. We should carve these out. I would agree with the chair. We should give those persons who have raised the concerns full opportunity. We give peace. However, it's been my experience, along with Commissioner Okuda, along with the chair, of the disappointing let's say, the disappointing presentations done by OPS in the past. Not, and I hope one day they will be able just to answer questions rather than diffuse. Thank you.
Thank you, Commissioner. Anybody else? Commissioner Carr-Smith.
Thank you, Chair. I'm still learning this process, but so I'm trying to understand why there's such an issue with OPSD and wondering, has anybody tried to sit down with them and express their concerns and try to figure out a way to go forward and have it work better for all involved? And I think that goes for the counties too. There seems to be some issues with some counties, and I don't understand why that can't be resolved through conversation.
So
if I may address that, Mr. Chair, unless you'd like to proceed.
I will make a comment directly to the question raised by Commissioner Carr-Smith, and then Mr. Orndecker, if you so still would like to further comment, I would welcome that. So as Commissioner Ohigashi just summarized, there has been an absence of, in my view, an absence of participation by OPSD in matters before us, and going back several months. And on my personal account, I did address the representatives who did show up at meetings and informally asked, where is everybody? Why aren't you taking this seriously? Why are you leaving the matters for us to discuss on the fly? And the general response that I got was, well, we have vacancies in our office and we don't have enough people to do our work that we're required to do. So I followed that with a letter that I authored and signed and sent to DBED, in which I enumerated the issues as I saw them and asked for their support and to have OPSD more present and supportive. I've not received any response to it. So that's the role that I've played. So we haven't been just quiet on the issue that I know of. So Mr. Orndecker, would you like to comment?
Thank you, Mr. Chair. First of all, with regard to the counties are not the problem. We get good participation from the counties. With regard to OPSD, this has been an ongoing problem for 4 or 5 years. And I've had attempted to resolve the matter several times. I don't know the answer as to why there hasn't been a resolution, but it's not for lack of trying.
Thank you.
Thank you. Any other comments on the motion? So I'm going to, the chair is going to support the motion and vote aye. And you've kind of surmised my reasoning by my comments I've made in the last half hour. But I'm going to, for the record, want to say a few things. First of all, this commission is not, quote, hamstrung, end quote, anyway from doing its business by virtue of the fact that we're operating under administrative rules that need to be updated. In other words, we can go forward with our business, even though there are elements that obviously need to be updated. So in that respect, I don't see the 3-month delay or deferment being consequential in terms of our ability to do business. Second of all, I think that this commission can do better work when it has important matters that are clearly on the record and in writing as opposed to just relying purely on verbal testimony. So I think that the commission will make a better informed decisions, provided we give opportunity to those who have legitimate concerns to express those concerns in writing, put them before this commission. So that this deferment gives them that opportunity. Whether or not they take advantage of that opportunity will also tell us how serious they are about their concerns. So it works in that way. And then the third comment I'd like to make is back to staff and to the AG, that it would also serve our commission better if you could enumerate in writing what those concerns are, and we don't have to rely on staff's interpretation of emails if they are matters of substance, even if they might just be discretionary. They kind of sound important to me, and I'd like to see what they are. So let me ask in the interim that staff and Attorney General provide a summary of what those issues are so we can distinguish them from other matters which might be more controversial, and that be done within the next 3 months as well. So for those reasons, I will be voting in support. And I also see Commissioner Ohigashi has his hand up again, or I forgot to take it down the last time. So Commissioner Ohigashi, do you have further comment? No, okay. So let me ask, go ahead.
Mr. Chair, I'd just like to make one comment. For the most part, I agree with your statement that we can move forward without these rule amendments. However, I would like to point out, I believe it's the change to 151595C that may expose us to reversal on special permit decisions if we don't change our rules.
Could you, for the record, put that change on, could you read that change that you're talking about?
This language, before I go forward, Scott, do I have the right language? The Thomas versus Chicago Park District case? Yeah. This language arose from a case that didn't even involve us at the beginning. The county made a decision with regard to special permits that was made under their rules, but their rules mirrored ours. And the change that the Thomas case gives rise to is certain unusual and reasonable uses within the agricultural and rural districts, other than those for which the district is classified, may be permitted. When determining whether or not an unusual and reasonable use is permitted, the County Planning Commission and or the commission, if commission approval is required, may deny a permit only if one or more of the following guidelines is determined to be violated. It sounds like we're dancing around on the head of a pin, which we really are, because the prior language just said may permit it. The following guidelines are established, and the federal courts determined that that was too vague, and there was a due process issue with regard to that. And I do not believe that this is a significant issue, and that we may perhaps handle this in any special permit decisions by actually reciting this language as a part of the decision and order. However, that doesn't mean that it won't be challenged.
That's a great point, Mr. Orendaker. I think we don't have a choice except to follow the direction that you're talking about. I mean, even if we propose even if this commission today voted in favor of moving forward and posting these draft as drafted, we'd still have that problem for 6 to 8 months.
Yeah, that is correct. I just wanted to make the commission aware of that potential issue. Yeah.
And when I read that draft language, there were some grammatical errors even in the draft that I noted in terms of the grammar that was used. So it needs updating anyway, but in my mind.
Yeah, well, I don't know. The
Point well
agents
taken.
sometimes get overactive.
Okay.
Gary Okuda.
Commissioner Okuda.
Yeah, thank you, Chair. If I may just comment on that. You're correct that during the interim, there may be these issues that we just can't get to because we can't do anything within 24 hours. But even if there is this problem, we probably can handle it in terms of questions at the hearing. For example, you know, if the party who claims vagueness is asked to explain what is vague, their testimony may actually show that they really don't have a factual basis for claim of vagueness because they clearly understand what the standards are that's being applied there, and they might actually testify during a petition or hearing on their petition that they really understand everything and nothing is confusing, and in fact nothing is vague. And so since of course the Deputy AG can better answer or correct me if I'm wrong, but if you don't preserve your objection on the record in front of the agency or the court, then it's deemed waived for purposes of appeal. So I think a lot of these things in the interim, we can handle it with assistance of the Attorney General and with questions at the hearing. Thank you.
Yeah, and to that point, just the fact that these rules have been drafted and presented to us by staff, it puts issues such as that front of mind with us, that we have to be cognizant as we proceed in hearings and matters during the interim before these rules are officially changed. Anybody else want to comment before we take a roll call vote? Commissioner Lee.
Sorry, just one quick question. This would be for Mr. Morris. Do you agree that you would be there to advise us if there was something that we, you know, was against case law?
Yes, that's certainly my role.
Thank you, Mr. Morris. Thank you, Mr. Chair.
Thank you. Okay, I think we're time for, unless somebody else wants to comment. Mr. Orndenker, please take a roll call vote on the motion.
Thank you, Mr. Chair. The motion is to defer this matter for a period of 3 calendar months. Commissioner Okuda.
Yes.
Commissioner Lee.
Yes.
Commissioner Kahele is absent. Commissioner Atta.
Yes.
Commissioner Carr-Smith.
Yes.
Commissioner Kamakea Ohelo.
Aye.
Commissioner Ohigashi.
Reluctantly, aye.
Commissioner Yamane.
Aye.
Chair Giovanni.
Aye.
Thank you, Mr. Chair. The motion passes with 8 affirmative votes.
Thank you. So Mr. Orndenker, I think it goes without saying, but I would encourage you and staff to, during this 3-month period, to reach out to not only the 4 entities that provided public and written testimony on this matter to us already, but anyone else that you feel can add or may add a specificity that will allow these things to proceed, because the intention is clearly at a hearing approximately 3 months from now for this commission to take this matter seriously and hopefully be in a position to move it forward in an affirmative manner.
Thank you, Mr. Chair. We will do so.
Great. Let's go back. So that closes this one. So I just want to comment for everyone that our hearing tomorrow, November 16th, is a meeting to be held at a remote location in the vicinity of Kona. And we intend to work through lunch and not take an extended lunch break in order to complete the business of this commission on an expedited basis and allow people to then take lunch after. So I just want to forewarn you, you may want to have a big breakfast if in fact we work a little bit extra time in the morning. If possible, let me ask staff to provide any food or drink that might be convenient for you to provide so that we could actually enjoy that during the meeting itself or during breaks in the meeting itself, but we will not be taking an extended lunch break. So with that, I think that concludes our meeting for today. Is there any further business to conduct today before we meet tomorrow? Hearing none, I'll adjourn the meeting for the day, and this meeting is adjourned, and I'll see you tomorrow in Kona. Thank you all.
See everybody tomorrow.